What does the Second Amendment protect?
Thank you, Mr. Chief Justice, and may it please the court. The Second Amendment, and I'd like to start by clarifying that we agree with the framework of Heller, protects two main rights. First, the right to keep arms, meaning to keep them at home. Second, the right to bear arms, meaning to them to carry outside the home. Where we disagree with petitioners is on the extent of that right. No right is unlimited, and that is doubly true with the Second Amendment because of the inherent danger posed by guns. We propose two main limits on the Second Amendment in the context of this case. New York's proper cause law is constitutional, one, because it has a proper cause requirement, and proper cause meaning that you should have to prove a specialized need for self-defense before you can get a concealed carry permit, is something that has a long-standing history. And second, because it is a more broad version of a complete ban on concealable weapons. Concealable weapons meaning handguns, pistols, revolvers, and things like knives that can be easily hidden. These concealable weapons have always been considered things that can be banned and have a long history thereof.
Why did the framers include the Second Amendment in the Bill of Rights?
I think again, here the prefatory clause of the Second Amendment is of special importance. It says that a well-regulated militia being necessary to the security of a free state, and that informs the operative clause of the Second Amendment, which is what enshrines the rights to keep and bear arms. In this prefatory clause, the framers make very, very clear that it is in some way this militia that is which is what underlies the Second Amendment. At the time of the founding, there was no such thing as a national standing army, and so it was expected that in times of war, the militias would come together and provide for the common defense. However, Heller goes one step further and says that this militia was not the only reason the Second Amendment was implemented. Rather, it was an incidental purpose to self-defense. Self-defense coming from the precursor to the Second Amendment in the English Bill of Rights. This self-defense idea is again something that the framers thought that individuals should have a right to, and that is the other purpose that informs the Second Amendment.
What are the limits of the Second Amendment's protection?
This is a pretty broad question, and there are a lot of moving parts to the Second Amendment. Who does it protect? What arms can people keep at home? What arms can people carry outside the home? What are the limits on how people need to store their arms? And quite honestly, a lot of these questions need to be litigated in future cases. What this case is about is what weapons can you carry outside the home? And again, we propose two main limits here. First, the idea that proper cause requirements are something that you can impose on the people who can carry outside the home. Again, that is something that is supported by history, starting with the Statute of Northampton in 1350, but then continuing to laws passed by Massachusetts in the 1800s, again in the 1900s, and to present day, where 6 separate states have such proper cause requirements. Second, we talk about concealable weapons. The idea that concealed weapons were generally considered dishonorable and things criminals did. If you wanted to have arms, you should bear it openly and you should do so proudly. This idea, again, is supported by the history. In our brief, we point to many cases starting in the founding era, but especially in the pre-Civil War South and post-Civil War South, where states banned concealable weapons, both concealed carry and open carry. And these laws are supported by case law, such as courts in Tennessee and Georgia, which clearly indicated that these did not violate the Second Amendment.
What weapons does the term arms include?
This is again a somewhat open question, but we think that you should look to Miller. And although Miller does have a shady history of only one party arguing in front of the Supreme Court it is still Supreme Court history that we read Heller to generally support. The idea in Miller is that you look to the prefatory clause of the Second Amendment, and you look to weapons that would be generally used by a militia. That is, not the weapons that could be valuable to a militia and effective insofar, because that would include things like machine guns and all military weapons, but rather the guns people would commonly have at home because a militia would be formed of people using their own arms. Heller points to things like handguns as a specific thing. But we make a second point here that the things you can keep at home are different from the things you can carry outside the home. Specifically, concealable weapons are, like handguns, are something that are totally acceptable inside the home. But once you get outside of the home, there is a rich history and tradition of making sure that those things are not allowed.
What is the difference, if any, between the verbs keep and bear?
Again, here we think Heller does a pretty good job. It recognizes that there are two separate rights enshrined in the Second Amendment. First, the right to keep arms. Again, Heller notices that the colloquial meaning makes a lot of sense in this context. That is, to own something at home, and thus you can use it for a militia. Second is the right to bear arms. And while there was debate in Heller over whether this had an explicitly military connotation, we agree with Heller's decision that this generally supports carrying outside the home. The thing we note here is that although the Second Amendment enshrines two rights, these two rights are not on equal playing field. Rather, the right to conceal, the right to bear arms needs to be severely more limited than the right to keep arms. This is because when you have a constitutional right, it is traditional that inside the home, you have a more protected access to it. Specifically, things like the Fourth Amendment are far, far more powerful within the home. And once you get outside of the home, such as a car, they have generally seen weaker protections. This is also extended in cases about obscenity laws and in Lawrence versus Texas. This thing we'd note is that this is especially true for the Second Amendment because of its purpose of self-defense. Self-defense laws have always been stronger inside the home than outside the home. And this is generally because inside the home, you don't have access to the police in the same way. And so things like the castle doctrine give you much more of a right to not retreat inside the home rather than outside the home. For the rest of the questions, my co-counsel Zachary will be answering.
Thank you.
What is a militia and why did the framers refer to it in the Second Amendment?
Thank you, Mr. Chief Justice. May it please the court. First, I think it's very important that we understand that our modern definition of a militia and the type we see on the news frequently is very different than that of a militia at the time the Second Amendment was written. When the Second Amendment was first written, there was no overarching national defense force. Rather, states had, for their own security, their own state-run private militias, which were composed of the private individual and their privately owned guns. These groups then were to be, in the time of war or overall state need, be called upon. The framers of the Second Amendment included this because they were all, to start with, staunch anti-federalists. They all opposed the idea of a federally controlled, large standing army, fearing the overarching threat of oppression from that. Rather, they thought that by including state-run militias, that this fear of a standing army could be avoided.
How should courts determine if a gun control regulation is considered long-standing?
We agree with Miller with the Miller case in terms of what establishes a long-standing law. In Miller, three such examples were considered long-standing. The first being restrictions on the mentally ill and criminals from owning guns, as that directly is harmful to safety. This law, for example, was established in the 1920s. Next, Miller establishes that it's constitutional to restrict the location in which people can carry guns, citing schools, hospitals, and overall public property are not necessarily a place where one can carry a gun unrestricted. And then lastly, it allows, in terms of commerce and the selling of a firearm, it deems background checks as a requirement of buying a firearm to be perfectly constitutional. We think then that these are a very low bar and therefore an easy burden to meet. In the instance of New York State's law in question, that law was first passed in 1913, making it older than the felon case, which was deemed long-standing within Miller. We then think, in addition to that, that New York has two additional reasons that are both long-standing for the right to have their law. The first being the right to control the type of gun in which people are allowed to carry. As other states have had this law since the early 1800s, it is therefore there is historical precedent that New York can restrict this. In addition, they can also restrict where people can carry firearms and overall what they can do with them.
What is strict scrutiny, intermediate scrutiny, rational basis review?
All of these methods are types of means-end scrutiny, which the goal of that is to balance the interests of the individual and the overall governmental interests. To start with, strict scrutiny is a form of review for existing statutes that has a preconceived bias and opinion that the law is unconstitutional. This is used when directly challenging laws that are, when looking at it, blatantly unconstitutional. This is frequently applied to things that typically use racial discrimination, for example, as a basis, as the courts have frequently found that there is no constitutional way to use race as a basis for discrimination. Intermediate scrutiny, then, which we think is the most appropriate manner of assessing gun laws, is a method in which analyzing laws where there is no preconceived idea of unconstitutionality or constitutionality. Rather, it simply is trying to determine whether or not something can be constitutional. It is important to note that the government interests and the rights of the individual are trying to be balanced in the usage of intermediate scrutiny. Intermediate scrutiny, as established in Heller, is the best way to assess gun regulations, as if we use strict scrutiny, there would be virtually no forms of gun regulation allowed. Lastly, rational analysis is simply a tool for courts to defer to the existing opinions of the government and existing precedent established by the legislative.
Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Yes, there is a very clear distinction between the open carrying of a firearm and concealed carry. First, it's important to distinguish that open carrying a firearm is very different from brandishing a firearm. Brandishing a firearm would be the carrying and displaying of a firearm in a threatening manner where it is evidently threatening, whereas open carrying simply means that the gun is completely and totally visible. When one first looks at someone who is open carrying, there should be no doubt that they have a firearm on their person and are carrying it. Whereas concealed carry, there is no such clear indication. When one is concealed carrying a firearm, it is not obvious that they're carrying it. It is somewhat hidden or obstructed from view. Carrying a gun in one's pocket, inside their shirt, inside their jacket, are all forms of concealed carry, as when one first looks at them, they have no way of knowing whether or not they have a gun. The framers of the Second Amendment themselves personally viewed that concealed carrying of a firearm is something only criminals would do, as anyone who is carrying a gun for good intent would make it very clear and would be proud that they are carrying a firearm.
How should the court consider the public safety implications of licenses to carry firearms?
It is important for the government, who has a social contract with their people, to view the overall good of everyone and try to balance that out with individual rights. This is, once again, another reason why intermediate scrutiny is one of the best ways to assess gun regulations. In 2019, over 14,000 people were killed as a direct result of guns, which is a significantly larger figure than the amount of people directly impacted by the right to have a singular gun. Therefore, it is the government's duty to try to balance this between the individual right to have a firearm and the overarching public safety, as since they are the government, they have to protect public safety and also not undermine existing rights.